Hi, everyone. Thank you so much for being with us here on 9 News at noon. Just a few moments ago, the Denver Gazette released new information from a file they obtained in part of an investigation into Elijah McClain's death. So a judge had previously ruled that even though the Gazette was given the file legally, they could not publish what was actually in it. With us now, we have Denver Gazette reporter Julia Carty joining us this afternoon. Julia, you were just talking about the roller coaster that your week was. We're going to get to that process in just a moment. First off, can you talk to us about what was in this file?
Sure. So our story is based on a motion for probable cause review and a request to dismiss the charges filed by Nathan Woodyard, who was one of the police officers charged in connection with Elijah McClain's death. And in the motion, his lawyers present evidence that was given to the grand jury by several medical experts who apparently said that in their opinions, the ketamine injection was what caused Elijah McClain's death, and several of them apparently said that they don't believe that the actions of police officers were his cause of death. And there were a few opinions about whether the actions of police officers interacted with the ketamine injection to exacerbate the whole situation, but the overarching argument by the lawyers is that they believe that the ketamine injection, according to the experts that were testifying in front of the grand jury, was Elijah McClain's primary, if not sole, cause of death.
So we're having some finger pointing happening basically in this new file.
That's right. There was at least one expert who I think gave the most definitive opinion that the paramedics deviated from a standard of care in that they didn't examine Elijah McClain before they injected him, that this injection of 500 milligrams, was clearly too big, factors like that. And so there was one expert that gave that definitive of an opinion that there was this deviation of a standard or from a standard of care.
And Julia, so how exactly did the whole process play out from getting the file to now being able to publish?
So it started, I want to say, mid-April, when I knew there was a hearing for the 5 defendants coming up. And I thought, well, I haven't checked on what's in the case file for a while. So I went to the Adams County Courthouse and just said, hey, I have these 5 case numbers. Can you just give me everything that's public? I think I asked for between February and that day, I think because that was shortly before the hearing, the previous hearing, so that seemed like a good time frame. And took the stack of records that they gave me and I went on my way. And when I got home and I started going through the records, I realized that there were a couple in there that were meant to be suppressed. And one of them was this motion filed by Nathan Woodyard's attorneys. And so I talked with my editors about it, and they said, well, why don't you just get a really good handle on what's in these records, and then we'll talk about what to do with them. And so as I read through this one motion by Nathan Woodyard's attorneys, I thought, well, it seems like it really is in the public interest for people to know why his lawyers don't think that there is probable cause to support the charges against him. And so my editors decided, we are in the clear to do a story about this because you got the records legally.
Right.
And so the idea of whether we could publish a story or we're going to be stopped from publishing just wasn't even on my mind. And so I had the story ready and we were set to go to print on it last Tuesday. And so about the day before, the morning before, I just reached out to the prosecutors and Nathan Woodyard's defense attorneys just to give them a heads up to say, hey, just wanted to let you know, I wanted to give you a heads up that this story is running because my understanding is that these records that it's based on are suppressed. And I just didn't feel like surprising them when the story ran was the right thing to do. And so I had a conversation with a spokesperson for the Attorney General's office, and all he really said after I sent him the email was he said, I'm going to need to talk to the lead prosecutors on this and get back to you. And he said, can we have a further conversation about this? And so I said, well, I'll probably need to loop my editor in, but I'm certainly happy to keep talking. And then later that afternoon, I want to say it was probably a little bit before 3 o'clock, was when we get this motion this order by the trial judge, basically saying that we cannot publish the story, we cannot publish the contents of the suppressed records, essentially, and that I have to destroy any copies that I have. So I immediately notify my editor, he lets our attorney know, and our attorney says, this is plainly unconstitutional. And so by the next day has filed a motion with the court for us, asking the judge to vacate her order for us to not publish, just saying that this is not at all constitutional. And so by, I think it was Thursday evening, once we had submitted all of our materials and the prosecutors had submitted their response, I think it was by Thursday evening, the judge had decided to overturn her previous order. And the stay on us publishing was in place until noon today, in case the prosecutors decided to appeal the judge's decision, and they chose not to do that.
Sure.
So.
And now here we are, 7 minutes past the hour. That article is out. We are fascinated to read it the second we get off air here. Everybody else, it is out there for you to read right now. Julia Carty, thank you so much for being with us. We can't wait to read your article.
Thanks for having me.
Absolutely.